the legislature, executive, and judiciary. Legislature is the one that makes the law, and executive is the one that implements the law, and the judiciary is the branch that interprets the laws made by the legislature. Basic structure doctrine is not just a concept, but a solution that was created for a problem. In earlier days, soon as we got independence, we had a new constitution with us. And there used to happen a lot of tussle between India's parliament and the country's top court, that is Supreme Court, for the power. So the tussle was because in order to determine who is superior under Indian constitution, whether it was the parliament or the India's top court, the Supreme Court. The root cause for the tussle between the Parliament and the Supreme Court was two important articles, namely Article 13 and Article 368. Article 13 basically states that if legislature comes up with any law that goes against the fundamental rights given under the Constitution, then such laws shall be declared unconstitutional by the courts of India. On the other hand, there exists another provision called Article 368. Article 368, to simply put, grants Parliament the constitution amending power. So as you can notice, on one hand there is the Supreme Court that says, hey Parliament, if you create any law that violates the Constitution's fundamental rights framework, I'm definitely going to declare them unconstitutional. And on the other hand, now the Parliament says, how dare you do that? I've got power under the Constitution to amend the Constitution, therefore you can't do anything. So this was the tussle that was going on between Parliament and India's top court. Now the situation is, there are multiple questions that needs to be answered. The questions are as follows. Whether the Parliament can amend any provision of the Constitution, including fundamental rights, or the Parliament has any limitations regarding its amending power under Article 368. So these are some of the questions that needs to be answered. Now, who will answer these questions? In fact, even the Constitution does not provide any answers to all these questions. When the Constitution does not provide any answers, now it becomes the duty and the role of the Supreme Court to answer the questions. So in this lesson, we will deal with what is basic structure, how it got evolved, and what are the provisions that are dealt under this concept, and some of the notable amendments and the case laws. So let's begin. It all started from First Constitution Amendment Act 1951. This amendment introduced Article 31A that provided the state with the privilege that they can acquire any land from anybody in the interest of the general public. Not just this, it also snatched the powers of the Supreme Court to review the laws made by the Parliament. It introduced a new schedule called 9th Schedule. So now what is this 9th Schedule? Think 9th Schedule as a box. So the matters that are kept under this box will not be questioned before any courts in India. The idea behind this is to make the laws made by the Parliament superior. Now based on the situation, India's Maharajas and the Zamindars were not able to file a case before the court against the land reforms that has been passed by the Parliament. So a person called Shankari Prasad now filed a case before the court, and the case was named Shankari Prasad vs Union of India. He argued that right to property being a fundamental right, it cannot be snatched away by the Parliament's amending power under Article 368. That being his argument, the court did not flinch. The outcome was completely different, and the court held that amendment as constitutional. The reason that was given by the court is that Article 13 does not apply in cases of amendment made to the Constitution. Article 13 only applies in cases of ordinary laws made by the Parliament and not under the Parliament's amending power under Article 368. Now, because the Parliament got the judgment in its favor, it got happy, and this happiness led the Parliament to make another amendment to the Constitution, that is 17th Constitutional Amendment Act 1964. Under this new amendment, Parliament placed more matters and laws under the 9th schedule. For clarity, I'll repeat again, the laws placed under 9th schedule cannot be questioned before any court of law. The new amendment was challenged in the case called Sajjan Singh vs. State of Rajasthan 1964. And again, the court did not flinch. It held that judgment given in the Shankari Prasad was constitutional, and it also upheld the validity of 17th Constitution Amendment Act. After this incident, the matter again reached the court, and now the court is in its feet. In Golaknath vs. State of Punjab 1967, the court woke up and by 6-5 majority gave a judgment. The court has held that Parliament cannot touch fundamental rights under its amending power, as Article 13 applies even in cases of amendments as well, when the Parliament does it under Article 368. Now, this judgment, which is given by the court, has overruled both Shankari Prasad and Sajjan Singh case. So now you might think the problem was solved, but you are absolutely wrong. Only after this comes the era of Prime Minister Indira Gandhi. In response to the judgment given in the Golaknath case, the then government of Indira Gandhi has introduced 24th Amendment Act 1971. This 24th Amendment made changes to Article 13 and Article 368. These changes were made to enable the Parliament to amend the fundamental rights. Following this amendment, another amendment called 24th Amendment Act 1972 was also rolled out. This later amendment introduced a new provision to the Constitution called Article 31C. This Article 31C has effect in two parts. The first part dealt with giving primacy to the directive principles of state policy over some of the fundamental rights, such as Article 14, that is right to equality, Article 19, that is freedom of speech and expression, and Article 31, right to property. And the second part took away the powers of judicial review from the judiciary. They made amendment in a way that whenever Parliament comes with a new law to enforce directive principles of state policy, if such laws goes against certain fundamental rights, those laws will still be valid. So that was the effect of the amendment. The government did not stop with this. They made another amendment to abolish privy purses of the farmer rulers. Privy purses is a concept where before and all Maharajas used to receive certain periodical payments for the land that they have given to the government. So now this privy purse concept was also abolished, and with the help of more amendments, she placed certain Land Reforms Act into 9th schedule so that they would not be challenged in any courts of law. So now the situation is many Land Reforms Act were placed under the 9th schedule so that they would not come under the scrutiny of judiciary. Now, aggrieved by these Land Reforms Act, Keshavananda Bharati, who is a chief priest in a mutt, has filed a case before the court. And this case was named as Keshavananda Bharati vs. State of Kerala, 1973. This case was the largest bench in the history of independent India. It consisted of 13 judges.
The decision was supported by 7:6 ratio, and this is a very important landmark judgment. So the court in this case has held that the parliament can amend any provision in the constitution, but it cannot destroy the basic structure of the constitution, which means there are some basic features that are inherent to the constitution. Only those basic features can never be touched upon. The court also held that judicial review is part of basic structure, and therefore any amendment that has been made to snatch the powers of judicial review, those amendments alone will be declared unconstitutional. Now this judgment date, that is 24th of April 1973, the date of this judgment is very important because it later served as a cutoff date for 9 scheduled cases. Now the doctrine of basic structure was created and things were going smooth, but after a while elections started kicking in. The case has been filed against the then Prime Minister Indira Gandhi for carrying out electoral malpractices. So while this case is being heard, the government passes another amendment called 39th Constitutional Amendment Act 1975. This 39th Amendment was deliberately rolled out to snatch the powers of the court to review the matters regarding elections of President, Vice President, Prime Minister, and the Speaker of the Lok Sabha. This amendment was challenged before the court in the case of Indira Gandhi vs. Rajnarayan, 1975. The court in this case had struck down the provision that took away the powers of the court to review the matters regarding the elections, and as a response to this, the parliament had come up with a new amendment called 42nd Amendment Act 1976. So much changes have been made through this amendment to the extent that this amendment, the whole amendment, is called as a mini constitution. Through this 42nd Amendment, the Parliament had again limited the court's judicial review and gave Parliament unlimited amending power over the Constitution. And this 42nd Amendment Act was again challenged in Minerva Mills versus Union of India, 1980. The court in this case had held that Parliament does not have any unlimited powers to amend the Constitution, and the power of judicial review cannot be snatched away from the judiciary in any situation. The court also held that the limited amending power of the Parliament is itself a basic structure, so that in future there is a clarity and there is no chaos and tussle between Parliament and the judiciary anymore, because it has clearly stated that limited amending power is itself a basic structure. And that is about the concept basic structure. Thank you.